Hey, good evening, everyone. Welcome to the Hillsborough Township Planning Board meeting of March 23rd, 2023. Please join me in a salute to the flag.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Do it real quickly, so there, call the roll.
Okay. Please be advised this meeting has been duly advertised according to Section 5 of the Open Publics Meeting Act, Chapter 231, Public Law 1975, otherwise known as Sunshine Law. Notice of the 2023 annual meeting schedule has been provided to the officially designated newspapers. The Township Clerk posts on the Township's website and available here at the Hillsborough Township Municipal Complex. In addition, application documents have been made available on the Township Civic Clerk website, and complete application files are available in the Zoning and Planning Department for inspection in accordance with the public meetings notice. And with that, roll call, please.
Mayor Lapani? Here. Mr. Wagner is absent. Mr. Ciccarelli is absent. Mr. Peason?
Here.
Mr. Julian is absent. Mr. Delcor?
Here.
Mr. Scobo?
Here.
Mr. Hashtag?
Here.
Mr. Radowitz is absent. Ms. Smith?
Here.
Chairman Sirachi?
Here.
Mr. Coyce?
Here.
I'm here. Mr. Hay?
Here.
Mr. Tollefson is here. Mr. Coyce, you want to talk about Mr. Lombardozzi?
Mr. Lombardozzi is currently going to be doing transcribing from home, watching from a private link to the video.
Okay. Well, welcome, everyone. Apologize for the late start. So, first up, we can go through a lot of items here. We do not have consideration of meeting minutes, nor resolutions, no planning board business meeting, and no considerations of ordinances. So next will be business from the floor for matters not on this evening's agenda. So if there's anything, you can come up to the mic, state your name and address for the record. Please note 5-minute time limit, and to avoid any conversations directly or indirectly involving warehouses.
Maria Janusik, 720 East Freck Avenue, Manville, New Jersey. I'm also a Hillsborough Township property owner, Block 86, Lot 32155, Camp Lane Road. I was present at the last Planning Board public hearing that was held on March 9th, 2023, which was shown on the Planning Board agenda as being for the application of Homestead 279 LLC, file number 22 PB05S/MSPB. I'm a Hillsborough property owner, Hillsborough property taxpayer, and an interested party. I had gone to the Planning Board office to see this file, and what was presented at the meeting was not in the file records at the planning office. I saw Mr. Coyce, we exchanged greetings, he saw that I was there. The application that was presented no longer had the subject property being subdivided, which changed the application, and Attorney Eric Bernstein, the Planning Board attorney, had stated more than once to you, Chairman Sirachi, that this was no longer the same application, and it was questionable as to whether the public hearing should go on. And you chose to go on with that meeting. I think that was a violation of property owners' rights, because the records for that application were not available in the Planning Board office. Also, since it was changed, property owners within 200 feet should have gotten notice of that, and instead the application on the agenda, it said that the application was being heard without renotice. I don't know how that's allowed to happen, and I know that the attorney, Michael Ogrodnik, was very upset by that situation, and he made kind of veiled threats, whether it was going to be about a lawsuit or whatever, but he wanted the application to continue, and you allowed it to continue. The other issue with that application was that there were fabricated stormwater test results provided. There had been also a memo which was addressed to you,
Mr. Chairman.
Yeah, I'm going to have to say, if you're going to make allegations, you're best to present that at the next hearing. Otherwise,
I'm not
please
making-
don't,
I'm not-
please
I'm
don't,
not making- I'm not
you
making
can't comment,
allegations. I'm
please do not
making
comment on an
allegations.
active application. If you need something on the record, this is not the forum to do it today. Do it at the next hearing.
At what next hearing?
The next time that application's before us.
Well, I want to state that...
No, don't state it
I
here.
did not have an opportunity, okay? I was at a meeting where things were going on that shouldn't have, and I yelled from the back of the room, which I don't like to do. But that's
And I
the
don't
only
like
way-
you doing it
That's
either,
the only way
so
that we can be heard.
at least we agree on something.
So I chose not to say anything, because I want to respect this process. I chose not to say anything, but how is that application allowed to go forward?
Mr.
Okay.
Chairman.
And as far as the stormwater test results... that was brought up
Mrs.
once
Janasek,
before.
Ms. Janasek, you're trying to
with
put
all due
stuff-
respect, you made a comment that Mr. Ogrodnik made veiled threats. I'm not going to say he did or he didn't, but if you want to buy the Border lawsuit, keep talking.
Okay. I was here...
Stop talking about an
Okay.
ongoing application of which, if you wish to make a presentation to this board, there's an appropriate time and place to do so. You are well aware of that fact more than probably anybody else in the room, other than the applicant and the board, since you attend almost every board meeting, etc. The time and place is Homestead 279's next application, or there is an alternative which you are well aware of that you can exercise, but the place and time to do that is not here and not now.
Okay, what alternative are we talking about? 'Cause
I'm not going to
I don't
explain
know.
that to you.
You're not gonna
You're
explain it to me.
bright enough to
I
understand
do not
that.
have an opportunity, when you have a application like today, you have an application, we're told we can't talk about that. Then you bring up witnesses specifically for certain things, and we can't talk about that.
Mrs. Janasek?
You don't have an opportunity during that application
You have,
to say...
Ms. Janusik, please, it's false. You're just stating false. You have an opportunity, like anyone else in the general public, can cross-examine every witness as long as you would like, that to your heart's content. And then at the end of the whole process, you get to come up and you get to state whatever your feelings on that particular application, for or against it. So you have lots of opportunities, and you're well aware of those. So it is duly noted that you disagreed with the continuance of, the hearing that occurred on the 9th. Is there any other items that you would like to
That
address?
application should not have
Okay,
been gone-
we've established
should
the
not have
fact that you
gone,
disagree
through a public hearing.
with how it was handled.
Okay, next
You have 1
question.
minute left.
The transcripts that are provided, the verbatim transcripts that are provided, they're being called mini transcripts. Why are they called mini transcripts? And who is the transcriber? I know that Mr. Lombardozzi is the court stenographer, but who is the transcriber?
Mr.
Since this is a quasi-judicial
Chairman.
body.
They're called mini transcripts, Mrs. Janasek, because there are 4 pages of the transcript on a page versus a standard transcript, which has 1 page per page. And we actually provide both, and my understanding is you request the minis. As for
I did
who
not.
transcribes the stenographer, Mr. Lombardozzi is a transcriber as well as the stenographer.
So he's the stenographer, and then he does the transcription.
Correct.
Okay. I never asked for a mini because I didn't know that such a thing existed. Thank you.
Thank you. Okay, doesn't look like no one else from the public, so we're going to move on to this evening's public hearing of Western Road LLC, file number PB-22-PB-03-MSPV, time of decision June 30th of this year, and this is a continuation from February 2nd of this year without further notice.
Mr. Chairman, couple of housekeeping situations, and I would also suggest, once I get past that the 3 attorneys introduce themselves for the record. We have received a certification by absent board member, examination of record eligibility to vote. Mr. Scobo has indicated he viewed the video recording on November the 10th, 2022. He is an eligible participant this evening. I've received the same document from Mr. Hashtag. I'll provide the original executed copies to Mr. Coyce. but all members of the board who are here this evening are eligible to participate in this application.
Thank you. So, first up, Mr. Gronick, you'd like to introduce yourself?
Yes. Good evening, members of the board. As you know, my name is Mike Ogrodnik. I'm an attorney at Savoshock Law Firm in Somerville. I'm here on behalf of the applicant, Weston Road LLC.
Lean in.
This is an application.
Why don't we let counsel for the other before you?
Sure.
Okay.
Good evening, board members, Mr. Chairman. My name is Mike Sinkovich. I'm with the law firm of Lieberman, Blecker, and Sinkovich, and I'm going to be co-counsel with Mr. Ash for the Hearthstone at Hillsborough Homeowners Association. Just a few, I guess, housekeeping items. We promised.
Sinkovich, can you spell your name for the record, please?
Absolutely. It's S as in Sam, I-N-K-E, V as in Victor, I-C-H.
Thank you.
Thank you, and as you've already learned, you need to lean into the mic, so well done.
Thank you.
Ash. Your turn.
Hello, members of the board. My name is Jordan Ash, A-S-C-H. I'm with the law firm of Riker Danzig. I am co-counsel to the Hearthstone Homeowners Association, which is appearing in opposition to the site plan application. Yeah, thank you.
Okay, thank you. Okay, Mr. Gronick.
Procedurally, this application was deemed complete approximately 1 year ago. First public hearing was held on November 11th, 2022, and there was a second hearing held on February 2nd, 2023, although the applicant was prohibited with proceeding with testimony. This application has since been revised to address essentially board comments and planner comments related primarily to the height. So the property had to be reduced based upon an interpretation of the height, and I'll get to that. And as Mike will certainly detail, there's several substantial changes to the plan, summarized as a substantial reduction in the square footage of the building from 140,155 square feet to 130,418 square feet. Of that, 125,118 square feet is warehouse and 5,300 square feet is office. Other material changes include enhancing the architecture, adding building color, as I said, lowering the building height, and slightly shifting the building. Additionally, again, responding to questions and comments from the board, we reduced the number of parking spaces from 139 to 99 and added those EV-ready spaces, 5 additional EV spaces. Frontage is on Weston Road. This is Block 185, Lot 1. Property is in the I-1 Light Industrial Zone and is 18.2 acres in size and is generally wooded. The applicant seeks to improve the property with 1 industrial warehouse building and an accessory office. And most importantly, the proposed uses are permitted principal uses in the I-1 Light Industrial Zone. The applicant's use is consistent with warehouse industrial facilities near the property, including adjacent to the property, which include 284 Sunnymead Road, which is General Tool, an industrial warehousing building, 113 Weston Road, Mindstone Construction, 101 Weston Road, industrial warehouse building, and generally a substantial amount of industrial buildings on Kennedy Boulevard, which are all in either adjacent or in close proximity to the site. Furthermore, this property is bordered by Norfolk Southern Railroad, which is a heavy industrial use. This property was approved by this board on October 4th, 1990 for a warehouse, industrial warehouse use. My research indicates that this property has been zoned industrial since at least 1983, and warehousing and office uses have always remained as permitted principal uses in the industrial 1, 2, and 3 zones. And interestingly, perhaps, these principal permitted uses remain permitted today. Section 188-106 provides that the purpose of the I-1 and I-2 light industrial districts is to create zoning districts recognizing the existing pattern of small industrial-oriented facilities, allowing the remaining vacant lots in the same area to be developed with similar uses, and provide areas for modest industrial operations. That was amended in 8/10/1982 under Ordinance 8211. Legal definition of industrial uses, although it can differ, are activities within land areas predominantly connected with manufacturing, assembly, processing, and storage of products. The proposed use of this property is entirely consistent with the stated purpose and the permitted uses as defined in the Light Industrial District, as confirmed by the planner's report dated November 10th, 2022, and the one this week dated March 21st, 2023, which states that, quote, warehousing, shipping, and receiving completely within the enclosed building and offices are permitted uses, close quote, referencing section 188-106B2 and 188-106B1 of the Light Industrial Zoning District. As we have stated at the prior two meetings, and I'm not going to detail somewhat tortured history of this lot, but in summary, the board approved the warehouse use and the accessory office as part of a settlement with the township. Since the township failed to inform the buyer of the property that there was a heavily contaminated landfill as part of the original sale of this subject lot from Hillsborough to Guastello. It bears emphasis that this property currently has approvals for the warehouse use, which was approved many years prior to the Hearthstone over 55 community, and specifically addressing, we understand that there are two attorneys from the Hearthstone community objectors, and I welcome all the members of that community. I appreciate this public process and this public precipitation. At the time of the Hearthstone application back in 2002, I think it was finally started construction in 06, 07, then planner Bob Ringelheim identified this exact issue, why we're here today, and affirmed that there are industrial warehouse uses that are permitted across the street from Hearthstone. Ringelheim also advised a 6-acre portion of the Hearthstone property that's in the airport safety zone would permit industrial uses, since the airport safety zone prohibits residential uses, I'm assuming in case of a crash or a safety issue with the airport. The Hearthstone project, adjacent to this site, adjacent to this approved warehouse project, was approved 12 years after the approval for the warehouse use. And I would submit that, although I'm incredibly sympathetic, I think that the residents of Hearthstone knew or should have known that their community was across the street from the industrial zone and that there was an approved warehouse use. This is exactly why Bob Ringelheim identified it in his planning memorandum when that application was proceeding. If you move next to a property that has an approved warehouse, I think it's slightly disingenuous to complain when the owner wants to construct not just a use that was permitted, but a use that was approved by resolution. This is especially so looking at the compliance with the bulk standards, especially the front yard setback, which requires 200 feet, and this building is 791.9 feet from the front yard, nearly 4 times the distance, or more than 2 football fields away from the setback line, with the existing apartment building approximately an additional 150 feet further from the road, or approximately 950 feet from the proposed structure. Furthermore, the site is heavily buffered with forest and an oversized wet pond detention basin with fountain in the front yard. At the end of the day, this project will likely be approved by the courts, who have historically provided firm guardrails against land use decisions that don't fairly adjudicate the land use regulations and ordinances. As indicated earlier by Ms. Janicek, this planning board is a quasi-judicial body, and for the public's education, this board is sitting just like a judge and jury that is obligated to objectively determine facts based upon the permitted uses and the proposed site plans. Decisions must not fall prey to prejudice, undue influence, political considerations, or the number of objectors. The Township Committee approved the warehouse over 40 years ago, warehouse uses over 40 years ago, has not removed the warehouse uses from the industrial zones, despite the clear authority to ban or limit the scope of warehouses as afforded under the police powers under Section 4 of the New Jersey Constitution. This board, perhaps unfortunately, is both legally and duty-bound by the ordinance that permits this use, and objectors' efforts to ban or limit warehouses should be venued with the Township Committee. As in the case with many applications before this board, and as a natural evolution of the development of this township, residential uses continue to encroach closer and closer to industrial-type zones that permit warehousing and other commercial and industrial buildings. Winding Way and Alls House is a prime example of recent subdivisions where there are $1.5+ million homes constructed in close proximity to industrial zones. If a buyer or a builder constructs or purchases a home next to an industrial zone, that does not eliminate the vested property rights of the industrial property owners and their constitutional right to build a project consistent with the permitted uses in the zoning district in effect. The 55+ older Hearthstone community across the street that was developed in the late 2000s. Yet, this township approved, support, and codified the industrial uses in the master plan decades before the residential use across the street, and in fact, as I stated, approved the warehouse use approximately a decade prior. I would have to agree what is reported in the newspaper today, that this and other applications have, quote, created a classic NIMBY scenario, not in my backyard, close quote. The great irony when you compare the Hearthstone lot to this project is that Hearthstone received approval for 185 units on roughly 25 acres of developed land with another 25 acres of open space, which is historically an incredibly dense project. The Hearthstone project has some of the densest single-family residential in all of Hillsborough, with almost no side yard setbacks. But for the lawsuit, the Hearthstone lot would be limited by a far lower density of single-family homes. Their lot has apartment buildings, houses, townhomes, tennis courts, a pool, recreational amenities, stormwater management, and an incredible amount of vehicle traffic: trucks, delivery vans, repairmen, visitors. In contrast, this project proposes 4 to 10 large trucks inbound and 6 to 10 trucks outbound per day. The Hearthstone building lots are in as little as 2,800 square feet, ranging up to 7,460 square feet, according to the public offering documents from Ryan Homes. My point being, the Hearthstone property is one of the most dense and intense land uses in all of this portion of Hillsborough, with far greater community impact than this application. It's essential to recognize, and is well-settled law, that the owner of the land has a right to develop their property, provided they can meet reasonable requirements imposed by the government. They cannot be denied their use of their property simply because neighboring landowners don't want changes to occur. As the court held in the precedential case of Pizzo-Manton, quote, the general purpose of land use laws may be effectuated by municipalities through their incorporation and ordinance, which is to, quote, provide clear standards to guide both property owners and planning boards. Pizzo-Manton 137 NJ at 230. My clients have spent hundreds of thousands of dollars to design and now redesign this project in reliance of the zoning ordinance, and are entitled to the protection of the ordinance outlines which provide clear standards for this application. This applicant meets the bulk standards in the Hillsborough Township Code. Minimum lot 1 acres, we're at 18.2. Lot depth 200 feet, we're at 791.9. Front yard 50 feet, we're at 159.6. Side yard 25 foot, we're at 25.1. Rear yard 50 feet, we're at 173.3 feet. Lot width 200 feet, we're at 883 feet. Importantly, max impervious coverage, where 60% is permitted and theoretically a larger building could be constructed, we're only at 49.4. We meet the buffer areas, and there's one bulk variance that has been opined upon by Mr. Coyce with respect to the max building height. In Mr. Coyce's memorandum dated March 21st, 2023, there's a citation to section 188-106, where the proposed height is 38.4 feet and where 35 feet is permitted in the zone. After redesign of this project, it bears emphasis that measured from the grade at street elevation facing Weston Road, this building meets the 35-foot height requirement. The front, according to my architect, the front of the building will appear to be at 34 feet, 4.75 inches at the front elevation under the street, which is under the maximum building height for the zones. In other words, prior to the change in interpretation, quote unquote, from Mr. Coyce on the eve of last hearing, the building height is compliant with the bulk standard from the street elevation, which was the prior point of measurement. Thus, we believe this application to be bulk variance free. The applicant, for the record, also believes that the township is bound by the prior planning director's interpretation of height, as was interpreted for many, many years, including before Mr. Maskey when it was Bob Ringelheim's reign. And he codified that interpretation in an email that's part of the record dated January 4th, 2021. When this application was deemed complete by the board, the applicant's position is that the board was barred from changing rules under the time of application rule under the state Supreme Court holding in Dunbar Homes versus the Zoning Board of Adjustment of Franklin Township. Again, the applicant is compelled to preserve our rights that the applicant justifiably relied upon the township planner's long-standing interpretation to their detriment in designing this project. Furthermore, the building is nearly 800 feet from the right-of-way, so there's zero impact on the neighbors as the building height that exceeds by 3.4 feet by the loading dock faces an existing industrial building and not any residential. In spite of all this adversity, this applicant is pleased to present the revised plans taking into account public and board professional comments, which substantially reduces the impact of this project of the community and proposed preliminary and major site plan squarely within the permitted use and industrial standards. This applicant stands before the board with every intention to be a good corporate citizen of the township and advance the goals of the zoning just like thousands of other small businesses and industrial uses that want to operate in Hillsborough. I would submit that there, according to the zoning, could be far more intense uses permitted in this light industrial zone other than a towel and linen web business. With me today, I have Mike Ford of Van Cleef Engineering as professional engineer, Ahad Arif as the proposed tenant operating as Miracle Brands, and Gary Dean of Dolan & Dean as the professional traffic engineer who will provide traffic testimony. We hope to conclude civil engineering operations and traffic at tonight's hearing, and we understand will continue at the May 4th hearing. And if there's a correction on the setback, I'm going to have Mr. Ford correct that. I would ask that Mr. Ford, as well as the board professionals, be sworn in.
Mr. Chairman, before we go any further, may I address Mr. Ogrodnik?
Sure.
Mr. Ogrodnik, I believe you're indicating that you don't believe a variance is required for height. I am referring to the revised submitted plans dated March 10th, 2023, where it indicates that there is a height of 38.4 feet proposed with an asterisk indicating that a variance is required. So I just would like to clear that up with you.
So the bulk standards table is reflective of your memorandum, and you've identified the height variance. The ordinance, how it's written, it says that the building height is defined by the grade to the top of the building, and then the second sentence says if the building is facing two frontages, meaning two roads, then it would be an average of the two. And for many years, and I believe Mr. Coyce has confirmed this, that the building height was interpreted to mean that the building height is measured from the elevation facing the road. That is now changed mid-application, which has necessitated these design changes. So is that correct, Mr. Coyce, that historically, am I correct that the interpretation was on the elevation facing the road, or if there were two elevations, an average?
I believe what Mr. Maskey had indicated was his understanding of how the building height was indicated, but just as the applicant has the right to bring on other professionals, the town was in a position where Mr. Maskey retired. I've been working for the town for 12 years. I was originally the zoning officer, and as I had indicated to you before, the zoning officer does more of the daily work in terms of interpreting the ordinance and how it works. And in my time working for the township and administering this ordinance, the building height, how it's interpreted, is exactly as it reads in 188-3, building height. The vertical distance from the grade to the top of the highest gable, slope of a hip roof, or otherwise the highest point of the roof, period. It then goes on to say, when a building faces on more than one street, comma, the height shall be measured from the average of the grade at the center of each street. As I look at your application, the property faces one street. Therefore, as a professional, I can't possibly give the applicant the benefit of any sort of averaging. In my professional opinion, I do not see how that part of the ordinance would apply to this.
Yeah.
And that's, I just want to make sure that that's clear on the record, and I have no comment regarding any planning director in the past that may have had anything to the contrary. All I could do is say is, as the zoning officer and now as the planning director and as the deputy zoning officer, this is what it says. If the applicant has an issue with that, would like it interpreted, you by all means can go to the Board of Adjustment, as you know. Thank you.
Mr. Chairman, may I make a brief statement? Yes. Thank you. I'm not going to reiterate everything that Mr. Ash said at the February 1st hearing. I'll just refer back to that on behalf of Hearthstone. The bottom line is, with regard to any prior settlements or prior approvals, that does not affect our standing and has no bearing on this application. We are here with regard to this specific application because the application is both inappropriate and it's an over-designed project. As Mr. Ash noted, in February, we have a position, a jurisdictional position, that we intend to lay out through cross-examination and through our witnesses that this is not actually a permitted use because it is not what a warehouse was intended to be when this ordinance was started. We have significant issues with stormwater management, which we will bring out. We have significant issues with the variance that was just discussed, as well as the waivers that are being requested, as well as the significant amount of parking that is not necessary for this size of a project, as well as the lack of buffering, and as well as the many other impacts that will be faced upon my client. For that reason, we believe that this application should be denied, and we will present our case through both our questioning and our direct testimony throughout this process. And I appreciate everyone's consideration of our position.
Yep.
I just wanted to make one correction on the front yard setback. I knew it was 4 times, but the building is 202.9 feet, where the setback is 50 feet. So that's my error. My apologies. Okay. I'd like to introduce Mr. Ford.
Okay. Yeah. What?
You want him to turn on the
screen?
Oh, you're plugged in, I'm sorry.
Yeah. Oh, we got to square you in over that way.
Once he gets plugged in.
Once it gets plugged in? Okay.
Raise your right hand, sir. You can sit down, Michael. Sit down. Just do it. The testimony you're about to give, truth, the whole truth, nothing but the truth, so help you God? Yes, I do. State your full name, spell your last name for the record, indicate by whom you're employed and your current professional licensures and qualifications.
Yes. My name is Michael Ford, F-O-R-D. I'm with Van Cleef Engineering, 32 Brower Lane, Hillsborough, New Jersey. I'm a licensed professional engineer in the state of New Jersey for over 30 years. And have appeared at the last hearing regarding this project, or actually the hearing back in November of 2022. So, and right now, what Mr. Coyce has turned on with the screen is an exhibit dated March 8th, 2023. Was submitted as part of the materials that were submitted to the Township
Mr. Ford.
Planning Department.
Mr. Ford, before you go on with the discussion of the exhibit on the farm, are you a professional engineer?
Yes,
Do you have a current professional engineering license with the state of New Jersey?
yes.
Any other qualifications you'd like to advise the board before they determine whether or not you are qualified as an expert for purposes of this application?
No.
Mr. Chairman, any comments from the board? Otherwise,
Okay. Since the last time you've appeared here, all your licenses and credentials have remained in good standing?
Yes.
Okay. Okay.
Thank you.
we're going to mark
Please
this
proceed.
exhibit as A1. Could you indicate, Mr. Ford, what A1 represents, please?
This is A3.
Well, is this, okay, we'll mark it A3.
It's a new exhibit.
Right, A3.
A3.
We had
Thank you.
A1 and A2 at the last. This is the site plan exhibit, as I said, was last revised March 8th, 2023. It was submitted as part of the record and should be on Civic Clerk. It's a colorized rendering of the revised site plan. It illustrates the proposed building in beige, the paved areas in gray, the stormwater management facility at the front of the site. And for the record, at a prior hearing, there was a request that in addition to what's being put on the screen, there was some public that wanted a color copy on the easel as well. And just for the record, I had already put that up before we walked up here, so that's the same exhibit, a hard copy of what is on the screen. Okay. So since the last hearing, we made several changes to the site plan and endeavored to submit a response letter to address each and every comment in the professionals' reviews, that is the planners, the engineers, the environmental commission comments, as well as the Chief Fire Marshal, Chris Winiger. The substantive changes are that the stormwater management facility, the basin at the front of the lot, basically increased twofold. The volume has increased approximately twice what it was at the prior hearing. That resulted in a reduction in the size of the building. The building was about 159 feet from Weston Road. Now it's over 200 feet from Weston Road because it was shrunk and reduced approximately 50 feet back from where it was previously. We've maintained the same access points for the driveways on Weston Road. The loading area configuration has remained the same with the exception of a small encroachment that was previously proposed within the township stream corridor has been eliminated. With regards to vehicular parking spaces, that total number has been reduced from 139 to 99 spaces. Therefore, the area of parking on the west side of the building has been reduced, and I'm highlighting now the green area that resulted from that reduction. The total amount of impervious coverage on the site, as was stated as part of the original, as part of the introduction, was at about 49%. As a result of these reductions in impervious area by the reduction in the building area and the parking, the total impervious coverage now is just over 40%, where 60% is permitted. With regards to stormwater management, what we've done since the last hearing is what resulted in the doubling of the detention basin size, and that is we have, as many of the board members know, some of the public as well may be aware of, the governor in May of 2022 had at a point said that there was going to be, or indicated that there would be an emergency order for changes in the stormwater management regulations. That, of course, is a professional in the industry. We've monitored that. That didn't happen in the summer of 2022. There was hints from our contacts at NJDEP that it might happen at the end of summer of 2022. That still didn't happen. What did happen since the November hearing and today is in December of 2022, the state published proposed changes to those stormwater management regulations that would result in new design standards for stormwater management. They haven't been adopted yet. They're not in effect. They wouldn't be applicable to this project at this moment. But what we've already done is taken the proposed future rainfall data from those published regulations and done an analysis and design to demonstrate that even with those new regulations, basically for quantifying what the changes may result in, is basically today for the 100-year storm, we're designing for 8.2 inches of rainfall within a 24-hour period. The new regulations would require for a 100-year storm event that design rainfall at a depth of 12 inches for a 24-hour period. So we've done that analysis, and I would suspect that probably this is the first time this board is hearing an application before them that implements the potential proposed new DEP standards for stormwater analysis regarding those new rainfall data events. So we've done that. So that's the resulting is the size of the detention basin. One of the other issues that was discussed at length at the last hearing is the discharge from the detention basin on this site and its impacts on the community across the street, the Westmead development. I know it as Westmead because that's the design plans that were approved by the planning board as part of that site plan. It's Hearthstone now. The impacts of this project's stormwater discharge on that community and specifically the detention basin, which I'm highlighting now on the plan, just to the north of our site, which is part of that Westmead community or Hearthstone. That's identified as Basin C in the stormwater management report that was prepared by others and approved by the township as part of that age-restricted community. We, since the last hearing, have, through an OPA request, secured a copy of that drainage report, reviewed that drainage report, and performed a supplemental analysis above and beyond what's required. That is an analysis for both this proposed project and that project, with the point of analysis for that project, which is the downstream side of that project, and what impact this project's stormwater management may or may not have on that analysis. And what we've, the results of that analysis indicate that the downstream point of analysis in that stormwater management report for Westmead, with this project being developed, would result in a reduction of the peak flow at that downstream point by approximately 6%, or about 16 CFS. That is, the total flow at the downstream side would go from 283 CFS to 267 CFS. That's a reduction, but I wouldn't say as an engineer, and I wouldn't claim here today that that's a significant change one way or the other with regards to drainage, but it is a positive result. It's a reduction. The other element of the stormwater management design that was changed was at our visit to the Environmental Commission, one of the Environmental Commission members suggested that we modify our stormwater management detention basin design such that the peak discharge from the basin be delayed. That is not a requirement. The state requirements are all about peak flow for quantity. But as part of this analysis and part of the redesign, which also further required the increase in the size of the detention basin for this project, we have accomplished that goal. That is to delay the peak discharge so that 10% of the runoff volume is still remaining in the basin 12 hours after the start of the rainfall event. In fact, we've accomplished 17 hours. And I think at the last hearing, there was some discussion about that request from the Environmental Commission, which was, not a requirement, and I'll say, I don't recall ever being asked to do that for any project in Hillsborough, and certainly would require some additional volume in the basin. And we said at the last hearing we would endeavor to achieve that goal, and we've in fact achieved that goal and demonstrated it in our stormwater management report. With regards to peak flows, and I said that we did the analysis based on the current rainfall data regulations and then the pending potential regulation changes that were published by DEP in December of 2022, and I understand right now they're in the public review comment period. So there's actually 3 storm events that have been analyzed, the current rainfall data, and in the new regulations there's a future existing, which is that substantial increase in rainfall, and then also a current adjusted increase. Basically, the current adjusted increase rainfall event that DEP has published is an analysis based on basically a 10% increase in rainfall from that which is currently required today. And for all 3 of those analyses, for both the 2, 10, and 100-year storm, we meet the peak flow discharges from this site. And I'll highlight just the more significant ones. For the 100-year storm for the future, the allowed discharge from the basin is 53 CFS, cubic feet per second. We're at 23, or less than half what is allowed. So not only did we endeavor to meet them, but we met them by a long shot. And then sorry, I lost my train of thought there. Okay. Thank you. He read my mind. Okay. At the last hearing, there was substantial discussion, like I said, about the impacts to the community across the street. One of the contentions was the impact to the basin, which I identified as Basin C on the project across the street. What I think was miscommunicated and not understood is that this basin, for the proposed project, connects to existing stormwater piping in Weston Road on our side, that is the south side of Weston Road, and it flows through the community across the street, but it does not discharge into that basin. So the flow from this basin does not flow into this basin. One of the things that resulted from our OPA request of the West Mead Hearthstone Project Stormwater Management Report is that report even specifically indicates that a portion of this site, that is the subject site, was never intended to flow through that basin, and there were drainage improvements in Weston Road to take that flow and bypass this basin. What flows into this basin from this site is a small drainage feature, and we discussed this at the last hearing as well, that's along the northeast corner of the site. That's a 50-foot riparian zone, which was part of a NJDEP flood hazard area permit that was approved under a prior application by the current owners of the property. That drainage feature does discharge into storm drainage on Weston Road and does flow directly into this basin. However, in the development of the plans for this project, we are not directing any of the impervious coverage runoff nor the basin discharge into that drainage feature. In fact, the existing drainage feature now encompasses a portion of the subject site, and because of the design of the portion of the site and directing the runoff from the developed areas of this site into the proposed basin, which bypasses the West Mead Hearthstone Basin, the drainage area to that basin C on West Mead is going to be reduced by about 4 acres. And in our off-site analysis for that basin, we determined that the discharge from the West Mead Basin, modeling it with that prior engineer's numbers for the basin configuration, would be reduced by 23%, and the actual volume to the basin runoff from our site would be reduced by over 70,000 CFS. So the drainage analysis for our site for quantity, as well as the off-site analysis, which again is the off-site analysis is not a requirement of the township code, nor I believe was it requested by the Environmental Commission or even the board's engineer, but we provided that separate analysis with all of the stormwater management numbers from the Westmead development plans and drainage report and the associated impacts or changes resulting from the change of land cover on our site. That is the subject site. With regards to stormwater quality, we continue to use mechanical treatment devices. While the pond-constructed wetland basin at the front of the site provides for additional water quality because the total drainage area to it is over 2.5 acres, that doesn't get counted for the water quality, but the 80% TSS reduction requirement for stormwater management will be achieved through mechanical treatment devices. And then with regards to groundwater recharge, since the last hearing, we have been back to the site doing supplemental soil testing, and this in-season soil testing has indicated that the site is not suitable for recharge. The groundwater table is too high, the permeability is lacking, and it's a D soil. One of the requirements or requests in the most recent review from your board engineer is that we provide additional geotechnical data supporting that, and we will. With the reclassification of soils to a D soil, Chapter 12 of the State Stormwater Management BMPs for soil testing indicate that when the seasonal high water table is at a depth of 12 inches or less, the exploration, excuse me, I'm a little dry already, may be terminated before the excavation to the depth of 40 inches below the existing grade, and the soils are classified as D soil. So by virtue of the shallow depth of groundwater table, it qualifies for a D soil classification. And in addition, there was permeability testing done, which will provide that data to your board engineer and supplement that testing as required to their satisfaction, that also demonstrate the permeability on site is lacking in that the basin flood tests were not successful. As part of the unconstructed wetlands, the NJDEP requirements are that such a stormwater management feature require a drainage area or has a drainage area of 25 acres in this case, or if it doesn't, that a water budget be provided that demonstrates that the permanent pool depths within the unconstructed wetlands will be maintained. We've provided the water quality or water budget since the drainage area to the unconstructed wetlands is less than 25 acres. We've also implemented the unconstructed wetlands in one respect because it guarantees the I'll say the most important element is the most important element with regards to quantity control. That is the volume of storage within the basin. By having a pond-constructed wetland with a permanent pool that doesn't, as opposed to, say, an infiltration BMP where a sand bottom, and you require or you rely on infiltration, and if that infiltration fails or is over time inhibited, you may lose part of that volume within the basin that you're counting on for your quantity control. The pond-constructed wetland doesn't rely on any infiltration. It doesn't pose a risk of something with maintenance over time where that volume above the permanent pool is not maintained. That is, that might be occurring if there was an infiltration BMP. Okay. Maybe we can just go to the review memorandums. There's a March 21st, 2023 memorandum from Pannoni Associates. There are a number of comments that indicate satisfied. Those comments that aren't indicated as satisfied, I would report to the board that we would address each and every one of those comments to the board's satisfaction or the board engineer's satisfaction. And I would note that some of those items that are not satisfied include elements such as provide a construction cost estimate for performance and bond quantity determinations and for inspection fees, which is typically not completed until the plans are finalized and stamped approved. As I indicated, there was a request regarding the geotechnical soil testing that we agreed to, and then with regards to our outside agencies, including the Delaware and Raritan Canal Commission, excuse me, those applications are pending, and we would address each and every one of those outside agencies. That is specifically the Delaware and Raritan Canal Commission, the Somerset Union Soil Conservation District, and then certainly we'd have to, or actually the environmental consultant for the applicant would make application to the NJDEP for the freshwater wetland impacts, that is the averaging and road crossing, and with regards to other utilities such as New Jersey American Water for water supply prior to construction, their approval and a contract for service would need to be finalized, as well as the HTMUA approval. That is the Hillsborough Municipal Utilities Authority. Two other items. There was a request from the fire marshal, and I don't believe we received an updated report from them. I didn't get one. We didn't get one from planning. But last year, as part of the initial submittal, there was a request from the fire marshal to provide for an emergency access lane around the entire building. That is the front driveway, the driveway to the parking, and the driveway to the loading and rear of the building provided access for emergency purposes to all but a small portion, and I'm highlighting it now, the southwest corner of the building. Since the last, the November hearing, we have, as part of the changes to the plans, added that emergency access lane. And that would be a grass paver lane in accordance with the township standards, used for emergency purposes only, not for the operation of the facility. And that's, my understanding, is not a code requirement, but a ask or a request from the fire official, and we have complied. And then with regards to the EV charging stations for parking, we've illustrated those compliant locations on the plans, and the building itself would be constructed in such a manner to provide for future for the future addition of solar on the roof, if the owner or applicant chose to do so. And those elements, both the solar capacity to bear the addition of solar panels on the roof and the EV charging stations, are state mandates. And as I stated at the last hearing, we would comply, and we have shown the EV stations on the plan. Can keep going. The pond constructed wetlands on the front. The basin has an embankment. That's an embankment we've analyzed that's compliant with the New Jersey DEP dam safety regulations. It doesn't rise to the need of a dam safety permit. It would be considered a Class 4 dam, only requiring local approval. With regards to landscaping, maybe I can just touch on this. One of the objectors' counsel mentioned landscaping. We have, as part of the design, shown this curvilinear driveway access in both locations and preserved wooded areas at the front of the site. Both of those factors, I think, inhibit direct views from Weston Road or off-site into the activity on the site. That is the activity in the loading area and the activity by the parking. One of the changes we've made at the last hearing, besides increasing the setback of the building from Weston Road, is we've added this green area in the loading area and landscaped it, again, to endeavor to obscure any direct lines of sight for activities in the loading area or and then with regards to the parking, we've again captured and maintained these existing wooded areas to block those areas as well. So that's the essence of the landscaping, and the separation from the public road. Not only has it got a significant horizontal distance separation, where a building could be as close as 50 feet from Weston Road, where this one is over 200 feet from Weston Road, but it has a significant vertical separation. Therefore, this Weston Road is much lower than these areas in the back, and then the loading areas drop down to capture the loading dock areas with the 4-foot drop. So there's a vertical separation as well that I think enhances that screening. pause.
Okay. Which direction first? Which way should I go first?
Is Mr. Ford finished with his,
He seems to, or he's at least taking a pause, so
well,
it would be
if he's
appropriate
not,
to
if
let...
he's finished with his testimony, then that's one thing.
Right.
He's simply pausing for dramatic effect, and he needs to go on.
There's no drama. But I'll touch on a couple of the zoning and planning issues, although we'll have a planner to address them. Specifically regards to waivers, and I think this is repetitive testimony at the last hearing, and the planner's report identifies this. Excuse me. Mr. Coyce's March 21st, 2023 memorandum identifies the waivers on page 4 with regards to the buffer setback for a small portion of the loading area immediately adjacent to our industrial use neighbor to the east, where 16 feet is proposed and 30 feet is required. The parking space sizes and access aisles are proposed at 9 feet and 18 feet versus 10 and 20 feet required, and 20 feet wide versus 30 feet required. Our tractor trailer spaces in the back against the building are 12.75 feet by 60, and then the trailer parking spaces are 15 feet by 30, so I don't believe that waiver is applicable anymore. And then with regards to site signage, I'll defer to the architect. And yes, we are requesting the economic hardship waiver as per the township code regarding tree mitigation. That is a threshold of 1.5% of the total construction costs of the project. And I'll stop now.
Mr. Chairman, can I take a couple of minute recess to talk to Mr. Coyce?
Certainly, so it's about 8:35, so...
8:40.
8:40?
Yep.
So we'll reconvene at 8:40. Okay, Mr. Bernstein, who should I go to first? The attorneys or?
Let's start with any of the profession,
Yeah.
Mr. Hay or Mr. Coyce.
All right. Mr. Hay. Are you deferring to Mr. Coyce?
Deferring to Mr. Coyce.
Okay, Mr. Coyce, you've been deferred to.
Thank you. Mr. Ford, regarding, are you able to answer questions regarding the tree mitigation requirements?
Yes.
Okay, so in my report that I recently submitted, I had some concerns that the information wasn't provided to justify the economic hardship waiver of 1.5%. Can you indicate where you have provided that information to show the formula, to show that it complies?
Yeah, part of our, can you hear me?
Yeah. Can hear you.
Part of the, as part of our original application, we provided that analysis.
Closer, Michael.
You still?
Yeah, just pull the mic closer to you.
Yeah, I'm looking at David, and part of our initial application included the economic hardship waiver calculation.
Okay, thank you. It's in the original application, you said?
Correct.
Okay. And then in terms of the other sections of the mitigation, let's see here, so there's also a rider that's, did you provide the rider explaining why each tree is to be removed?
I'm not familiar with that requirement.
So
Each tree?
that's in section 188-163C1. So C reads tree preservation plan submission requirements. In addition to the standard development application form, the following information shall be required for approval for tree removal. 1, a rider explaining why each tree is to be removed. 2, a tree preservation plan that depicts the location, A, the location, species, and caliper of all trees to be removed on a survey drawing, B, the location, species, and caliper of each tree within the drip line of each tree to be removed, C, the quality, quantity, and limits of vegetation on the remainder of the site and within 200 feet of the property line, D, the location of existing and proposed structures, including parking areas, detention basins, and other stormwater facilities, E, existing contours and proposed grading, F, proposed preservation methods of trees to remain, G, the location of replacement trees, including a replacement schedule, including species, quantities, and size in accordance with 188, 164 mitigation required, comma, below.
Yeah, I wasn't familiar with the way you characterized it as a rider. We have provided as part of the plan set a tree mitigation plan, which I believe addresses each and every one of those comments. The trees that are being removed, the trees that are staying and being protected. Also, as part of the plan, there's a soil erosion and sediment control plan, which identifies the limits of disturbance and how the limits of disturbance will be protected with silt fence.
So here you have indicated that a contribution will be made to the township in terms of trees that you weren't, the applicant wasn't planning on proposing. Is there a reason why the required trees cannot be planted on the site?
Because the site is primarily wooded now, they wouldn't fit on the site. If this were a site where there was substantial open area, like an existing cultivated field, and then some woods, the tree mitigation for the wood disturbance could potentially fit on the site, but in a situation like this, that's not the case. And also, as you know, the minimum mitigation requirement is for every tree you cut down, 2 trees are put back, and that is a weighted schedule as the size of the trees increases. So in this case, since we're endeavoring to try to minimize our impacts to the existing woods, that leaves very little green space for replacement trees around the limits of disturbance or at the edges of the limits of disturbance.
Mr. Chairman, while Mr. Boyce is looking, Mr. Ford, has there been, the plan that you submitted this evening is an updated plan from the original plan, is it not?
Yes.
Therefore, wouldn't it require an updated tree preservation and tree mitigation requirement based on the change of the plans?
The plan has been updated. The tree mitigation formula requires a cost estimate for the project. That hasn't been updated, and that was one of the comments that was requested by the board's engineer, and we would agree to do that. And whatever the final number is for the...
Well, isn't it a requirement that in order for this board, which has the ultimate determination to grant or deny the waiver, that the required costs and information be provided for the board to make the ultimate decision whether to grant or deny the waiver and the mitigation?
I would say from my experience, factually, please, is that even if we were to agree on a plan and a cost estimate at the time of construction and the performance guarantee cost estimate, that number could have changed again.
But not as it relates to whether or not the board should or should not grant a waiver or the determination that you've met the requirements of Section 188, 160 at SEC, correct?
Great. In principle, we know we can't plant all the trees on site. There's not a possibility, and we know we're making a donation, a contribution. There's really only left to be the final determination of the contribution, and customarily there's always a revision to the plans for compliance, and at the time of the revision of the plans for compliance, there may be changes in the quantities of construction, therefore affecting that number.
Let me make it
Yeah.
simple, Mr. Ford. Is it the applicant's intention to amend any material submitted related to tree preservation and tree mitigation for purposes of board determination?
Absolutely, we will comply with the ordinance requirement of 1.5% based on the final construction cost estimate.
So the answer is no. You will not be submitting, for purposes of this board determination, what ultimately happens if your client's project's approved and if it goes to construction is an internal administrative issue. This board has to decide whether or not to grant the waiver your client is seeking. My question is it the intent of the applicant to submit any additional documentation relative to the current plan as it relates to what you've previously submitted?
If it's the board's pleasure, we
It's
can...
not, Mr.
Okay.
Ford, it's not the board's pleasure. It's a requirement under the code. Just asking a simple question.
Yes.
Thank you. And when are you planning on providing it?
We'll provide it before the next hearing and as a condition of approval if the plans change at that time as well, so that the final number can be calculated.
Thank you.
And, excuse me, Mr. Ford, on, in the exhibit that you currently have up, the lightly shaded green areas, are those areas for opportunity to have trees planted, or is there alternate landscaping that you have proposed there?
There's alternate landscaping there. I don't think I have all the plans.
Which are not, so they,
Right, like shrubbery or bushes and other landscaping and drainage.
but not any mitigation trees?
No.
Okay, is there a
But it-
reason why you're not proposing additional, or trying to address that?
No, there's not a specific reason, and if part of the review, and I don't recall seeing any landscape comments in your report. What number we're referring to with these comments?
Currently, there's no number in the report. It's simply looking at the entire tree preservation ordinance and also looking at your exhibit here. It prompted wanting to ask the question of
I just wanted
why.
to follow you in your March 21st report.
There's just a section in my report that I talk about tree mitigation as a whole. There isn't a specific
Okay,
detail
all right,
about this,
all right.
but as you're presenting, obviously, different things get prompted. And so we wanted to ask why some of those areas, or could there be an opportunity to mitigate some of those trees in that area?
And if there's a desire or an opportunity somewhere, we'll take advantage of it, if that's the preference, rather than having the trees as a contribution. For example, I think we spoke at the last hearing, if the objectors wanted some landscaping on their property, some of those trees could be planted there.
So, Mr. Ford, the reason why I'm asking it just, so that the board can understand, you had indicated earlier that, there was trees that were not being proposed because there wasn't any room. So I just wanted to be extremely clear if there is opportunity for the trees to be planted on the site instead of, through contribution, and if there's an advantage to those trees being planted and providing additional buffering, then that is something that the board may be interested in. So I just wanted to be clear.
And we're interested in it as well, and we would comply.
Thank you.
Mr. Chairman, I do have one more question for Mr. Ford.
Certainly.
And I granted that my eyesight is failing. There appears to be a small rectangular piece of property in the middle keep going, right there. It appears to have a separate block and lot number. Is it your client's property?
No,
Whose is it if you know?
I don't know.
Thank you.
Yeah, I think, just to clarify, I think to give you an idea of what the origin of that is, I think that this was originally, many years ago, part of a subdivision with many little lots that were carved up, and then since then it was consolidated, and there's just this one out parcel that is under separate ownership.
Do you happen to know who the owner of the property is? Is it listed on your site plans?
Mr. Bernstein, when they would have been noticed?
The issue is not noticed, Mr.
No, but I mean, that would have...
Yes, that's why I'm
So-
asking. It should be on this
So there should be a
200-foot
list.
list.
If we
Yeah, we
notice-
think this was one of those, if you can imagine a giveaway property as part of a newspaper subscription.
There's a lottery?
It's actually not all that uncommon.
Publishers Clearinghouse, is that what you're talking about?
Was it?
Publishers Clearinghouse?
Yeah, it's something like that from back in the 30s or 40s.
So I would imagine, Mr. Agronic, Mr. Ford, that then that lot would be untouched?
Yeah, that's the.
It would stay wooded?
Correct. That's why the building is located, preserving that forested area.
Mr. Ford, I believe just to save you some time, I looked on your cover sheet here with the property owners. It's Block 187, Lot 7, Heitzinger, B-E-S-T, care of Servideo, J. And this is out of Burbank, New York.
Burbank, thank you.
Mr. Hank?
Yes, Mr. Chairman, thank you very much. I did want to just go ahead and follow up on our engineering review letter that we wrote on March 21st, 2023. That was the review letter known as review number 2, follows up from October 24th, 2022, which was engineering review letter number 1. We obviously cited the changes that Mr. Ford discussed this evening with the building shrinking by nearly 10%. We also noted the parking spaces being reduced from 139 spaces to 99 spaces, the lighting plan being adjusted to conform to Hillsborough Township requirements, the stormwater management, which Mr. Ford discussed, and some of the changes that were revisions that were made with respect to that, the off-site analysis of impact report that was provided that we're going to need to obviously have some updates with, and then the proposed driveway that was removed to meet the stream corridor. So we're happy to see all of those changes. And with respect to the comments, I believe that all the comments were satisfied or at least met. I will highlight some of the ones that are still open, and that is, of course, the board going ahead and looking at variances with respect to parking stall sizes, drive aisles, in accordance with the ordinance. That's up to the board in terms of granting those variances. With respect to building height, same thing. We did note, of course, the applicant is proposing 38.4 feet. With respect to the maximum height, that's 35 feet. That's obviously a deference of approval to the board. We do have a comment in terms of architecturals that we note on top of page 4 that we do need to see what the height of the loading docks are. That was not discussed by Mr. Ford, but we're hoping that the applicant's next witness in terms of architecture will discuss that. There was no testimony concerning the building operations, but I understand from council this evening that they're going to present on their operations person and hope that they would address that. On comment 6, again, same thing with the trees. I did discuss this earlier with Mr. Coyce, and yeah, the light green shaded areas that are before you, I kind of figured they were shrubs and what have you. And if you look up at the plan, it is a substantial amount, and there is an opportunity for this applicant to go ahead and meet or get lessen the hardship that they're looking for. I would advise them as such, especially with the fact that they do have a tenant and the fact that it's very akin to warehouse projects. You don't see a lot of shrubbery. You see very little shrubbery, in my estimation, through the state of New Jersey. So I would ask the applicant to look at that and keep that into consideration if they're to come back with a revised landscaping plan and a mitigation plan. With respect to the handling and collection of refuse, I would hope that this evening we hear that from the applicant's operations and understand that. I did not hear any testimony this evening about how this applicant is meeting the warehouse guidelines, Law Bill A3352, and whether or not and how that's going to be met. I'm hoping that the planner would be able to go ahead and testify on that, talk a little bit about that as well. I'll defer to to the applicant as to when that will happen. There's another item in terms of structural design calculations on item 11. I would ask the board to make that a condition in terms of resolution of compliance if this application will be approved by the board, and that is at the bottom again of page 4. Stormwater management, obviously we'll be looking for some off-site, or I should say, some approvals outside of the board, that with the DRCC. There were numerous other items that were satisfied. They also did clarify this evening the test bits that were done about what the soils group should be, as well as whether or not the site could infiltrate.
Sorry. Can you slow down just a little bit? I'm having trouble keeping up with you.
Sorry about that. So I want to make sure, Mr. Chairman, that it's understood. It appears that the applicant has gone ahead and met the requirements. We will thoroughly review it, but from our estimation, those requirements have been met, and I don't have any issues with respect to test pits. We did have an issue at the bottom of page number 6, and that is on item 12, that we asked the applicant to revise the pipe capacity analysis. Typically, anything with velocities over 10 foot per second in piping should be amended and mitigated, and it should be less than below 10 feet per second. So we're asking the applicant to go ahead and revise those plans. That could be also a condition of approval. I don't know if there'll be too many substantial changes with that, so I'm not really too worried about that. The rest of our letter contains traffic impact. When you get to miscellaneous on page 7, again, outside approvals, the applicant did go ahead and testify with respect to freshwater wetlands that is still outstanding. I would hope that the environmental consultant could give us an update on that. And then, of course, on item number 4 with the separate cost estimates for public and private site improvements, obviously that's for performance and guarantees. That would also be, I'd ask the board to make that a condition as well. When you get down to the end, not too many other items throughout the letter. I think they've addressed many. I will also note to the board on October 27th, a supplemental environmental review letter number 1 was prepared by our office that would really more or less examine the environmental impact statement. I'm not sure if Mr. Ford is the witness that will testify on that, but I will say that in that particular report, again, we note that we would like to hear testimony on how this application is going to meet the warehouse guidelines. That is throughout this letter in terms of what we concluded. Looking to see if there was anything else that we highlighted. That probably is it. There are some other issues that I'm hoping that their environmental folks will answer in terms of testimony with adverse impacts of wetland areas. Not having an LOI in this area, I don't know if there's threatened and endangered species. I don't know if you're going to have to erect fencing for turtles and what have you. I can't tell you that, but I can tell you that it's incumbent upon this applicant to make sure that they address those issues, and they should address those in testimony, so it's understood as to what the environmental impact is or what's anticipated as they go to get a letter of interpretation. So I think that's very incumbent and very important that the applicant come back and provide testimony with respect to that issue. Mr. Chairman, with respect to item number 4, or I should say page 4, environmental phase 1 investigation, my office did review some of the other environmental impacts. I'm hoping that the applicant will be able to go ahead and address those this evening. I don't believe Mr. Ford is equipped to do that, as well as the environmental phase 2 investigation. We have numerous items that we have asked for clarification on. I believe that that's, again, going to require testimony from their environmental expert. Mr. Chairman, that concludes all of our letters and findings. The only one that's outstanding, again, as I mentioned, is the traffic report. It's both in the engineering letter as well as in a supplemental traffic engineering report that I believe Mr. Dean will be testifying on this evening. Thank you.
Okay, thank you.
All right. So just to reintroduce... I'm sorry? No. Just to reintroduce myself, I'm Jordan Ash with Riker Danzig, representing the Hearthstone Homeowners Association.
Talk into the mic, please.
Yeah.
You're going to bring it down. And you might just want to speak up a little bit.
No problem. So, Mr. Ford, I just want to start out by asking, you would agree with me, would you not, that regardless of any other outside considerations that may have been discussed tonight, this site plan application must comply with the stormwater and other relevant environmental standards. Is that correct?
Yes.
All right. And I'm trying to understand one thing about the change in the stormwater management plan. For the prior iteration of this application and at the November 22nd hearing, it was indicated by you that this site would drain to the Hearthstone Basin. Do you recall that testimony?
I think that there was a miscommunication because the site drains to or connects to the drainage in Weston Road on our site, and the data we had for the Hearthstone community wasn't available to us until we got the OPA request for the design of that project, and that's when it became apparent, like I said, that this basin doesn't drain to that basin.
So when you previously submitted this application, you believe that it did drain to that basin, is that correct?
Yes.
Okay, when did you submit that OPA request?
Since the last hearing, because at the last hearing, we were also, asked or suggested that we look at the overall impacts to that project, and we've endeavored to do, like I said, the separate, downstream analysis that isn't required, but we did it to demonstrate no impact.
So your original application that you put before this board was proposing to drain water into the Hearthstone Basin across the street, but you had not confirmed even that the water actually went to that basin, is that correct?
No, our original application indicated that we were connecting to drainage within Weston Road. For example, you could ask me of where the drainage from the Hearthstone community drains to, and I may or may not know where it goes, but it's not applicable to the standards. The standards are the point of analysis just at your point of discharge. Our point of discharge was at that existing drainage feature in Weston Road. And I believe that you would agree that since the last hearing, that the additional information to be able to do the off-site analysis not only demonstrated no adverse impact, but demonstrated that our site flow reduction to that basin is reduced.
Well, in terms of my agreement, I'll just state we do have a witness that will speak to that. But I really just need to understand this particular point. So it's your testimony then that it didn't matter where the water went once it left your site?
It wasn't a requirement of the analysis. This is additional details that we've done and prepared as part of our request from reviews from both the Environmental Commission, the Township Engineering Department, and public comment.
Okay, so I'll move off this point in just a second, but you're telling me that if it were the case that you were putting water into the basin and it were to overflow the basin and provide overcapacity for that basin, that wouldn't matter at all to your site design?
Objection, it's irrelevant, and because that's not the current design. It's also speculative.
I'd like an answer to that question. Are you directing your witness not to answer?
I put my objection on the record, and I'm looking at Mr. Bernstein.
Objection.
Why are we talking about a plan that's not applicable anymore? How is that relevant to this application? That's not the application.
Rephrase the question, Mr. Ash.
What changed in the site conditions that the water is now going to a different place?
It didn't really change. That wasn't the thrust of the change in the basin design. The thrust in the change in the basin design had nothing to do with whether it was going to that basin in a pipe through the community across the street. It had all to do with, number one, doing a design that not only complied with the current rainfall data, but the potential proposed rainfall data, which is substantially greater, and the delay in the peak discharge that was suggested by the Environmental Commission.
All right, so you're now putting the water to what is, and correct me if I'm wrong, but it's a privately owned pipe that's running under Weston Road and essentially through and then onto my client's property. Is that correct?
We're connecting to a public pipe in a public road.
The pipe that you're putting water into is a public pipe?
Yes, we're connecting at Weston Road, and the pipe is on our side of the road.
Does that pipe
We're not doing anything to the pipe on the under Weston Road or through your client's property.
But that's where the water is going, correct?
That's correct.
Okay. Did you do any analysis on the capacity of that pipe to handle this water?
Yes.
Where is that analysis?
It's in the drainage report.
Which of the drainage reports?
It's in the stormwater management, the calculations for the pipe capacity, the same pipe capacity that Mr. Hay would have identified. The couple of areas were over 10 CFS, or 10 feet per second.
Can you point me to in your report where you talk about this?
I can... in the design calculations, the existing, it's a 24-inch by 38-inch elliptical pipe, has a capacity of 26.74 CFS.
Can you tell me where you're reading from? I'd just like to follow along.
I'm reading from my summary of the design analysis we've done.
I mean, it's a 500-page report. I'm just looking for a page.
Do you have a copy of the report for Mr. Ford? Are you going to ask him to go through every page to find?
I'm not. I just want to know where he did this particular analysis so I can
told
know
you.
what he's relying on.
All right, well, we're going to answer this way
Yeah.
with our summary.
I'm just asking him to direct us to where he is reading from in his own report. I don't think that's out of line at all.
Do you have a page? Just give him the page number.
No, I don't have a page number.
So what are you reading?
A section.
So you're reading a summary report? What are you reading?
Right.
Does he have a copy of what you're reading from?
I believe it's in our drainage report, in the stormwater calcs for all the pipe analysis.
So just to be clear, maybe I was mistaken.
And if it isn't, we'll provide it. I mean, it's not a dispute. I'm giving you a specific number that obviously I didn't just pull off the top of my head.
No, I'm going to take a step back because maybe I was
I'm pretty good, but I don't remember that well.
Understanding what was being read from. Were you not just reading from your report, you're reading from your notes?
Yes.
Okay. Please proceed.
I answered the question. Yeah.
If you could one more time, please.
Okay. The analysis of that existing 24 by 38-inch pipe has a capacity of 26.74 CFS.
Okay.
And just to be clear, typically drainage pipes within public roads are designed for a 25-year storm, not a 100-year storm. So evidently this original design may not have been for a 100-year storm, because certainly our existing flow could be over that for a 100-year storm. But we've endeavored to not only reduce the rainfall peak discharges from our site to comply with the stormwater management regs, but also to address just what I think, what was your name again?
Mr. Sinkovich.
No, your name.
Me?
Yes.
Mr. Ash.
Mr. Ash, I'm sorry. What Mr. Ash was asking, that whether we looked at the capacity of the pipe in Weston Road.
All right. How much water flow is being diverted that would now go to the state open water that's now being diverted to this pipe?
The state open water, are you referring to this drainage feature on the northeast?
Yes, sir.
Okay. That actually flows into Basin C on the site. It doesn't go into this pipe.
I understood, but according to
That's your question. Your question was just how much water from this state open water goes into this pipe? My answer is 0.
No, that wasn't my question. I'll rephrase the question. You stated in your testimony, in your report, it appears that there is water that would, if pre-development, flow to the state open water, that is now flowing essentially to this pipe. How much water flow is being redirected in that capacity?
Again, the state open water, I'm sorry, Mr. Ash, it doesn't connect to that pipe we're referring to that we were just talking about where the basin discharges to. There's more than one pipe. There's a second pipe that takes drainage from the state open water, and that goes into the basin C.
And I
So it doesn't
appreciate
go to the
that.
same pipe.
But my question is, there was testimony, and it's in the report, that there was water flow that was going to the state open water that is now going, I guess it's going first to your pond-constructed wetland and then to the pipe.
Correct.
Okay, how much water flow is being rediverted in that way?
That's about 4 acres is being reduced to this state open water that goes to Basin C, and that's collected and managed with the basin.
Okay, and in your analysis, has that 4 acres been added to the capacity that pipe is already undertaking?
Yes.
And it's based on the summary you read before?
Yes.
Okay. Bear with me for a second. What happens if that pipe does receive more flow than it can handle?
Be like a rain event that's more than what the design capacity, and it would exceed the capacity and flow up into the roadside swales or ditches at that location.
Okay, and the proposed basin has an elevation of about 65.15 feet, is that correct?
The proposed basin has many elements: a bottom basin, top of basin.
The highest elevation.
Okay. .8 is the top of the embankment.
Okay, and are you aware that the manhole rim elevation above that pipe we're talking about is at 59.8 feet?
Bless you.
Just looking on our upslope side of the road, there is no manhole. It's just an open pipe.
I'm referring to the manholes actually on the Weston property and possibly along Weston Road, but I think on the Hearthstone property.
There's several manholes on the Weston property because the pipe traverses, through that property.
All right, I'll move on. With regard to the emergency spillway from your proposed basin, is my reading accurate that it's essentially pointed directly at the Hearthstone Clubhouse?
It's, yes, on the Weston Road side of the basin, the downslope side toward Weston Road.
All right. Under what legal authority are you proposing to direct water runoff from the applicant's property to my client's property?
That's really a legal question. I'm not a lawyer.
You're not aware of any agreement, easement, anything of that nature?
Again, a legal question, I would defer to others.
You wouldn't look into that before designing a site such as this? And
Objection asked and answered. Move on.
I don't think it's a new question. I mean, to
And
finish it.
instruct my client not to answer the question.
Based on attorney-client privilege?
No, because it was asked and answered. He said it's a legal question, and he said he's not a lawyer. That's the answer.
And I was asking a new question that was interrupted from before you even made your objection.
The question was, I believe, how did you come to the determination that you came to related to the issue if you didn't have any understanding of the legal perspective? Is that correct, Mr. Ash?
That's a fair characterization of my question, sure.
Would the witness answer the question? To the extent the witness can answer the
Well,
question?
I've said several times that we're connecting to a existing pipe within a public right-of-way that gathers runoff from this site as well as the Western Road, and actually was included as part of the West Mead Hearthstone Development Project plans identifying drainage from this site going through that site. From a legal standpoint, I defer to others.
All right. Have the revised site plans been submitted to DRCC for a new approval?
No.
Do you intend to submit those?
Yes.
When?
As soon as my workload permits.
Prior to this next hearing?
When's the next hearing?
May 4th.
Yes.
Okay. Let's move on and talk about compliance with the stormwater management rules, NJAC 7:8. You're familiar with those rules, sir?
Yes.
All right. And would you agree with me that the three performance standards under those rules are groundwater recharge, water quality, and peak runoff?
Yes.
All right. Let's start with groundwater recharge. So am I correct that despite your 11 acres of disturbance and about 8 acres of impervious coverage added, you're proposing no recharge? Is that correct?
Yes.
Okay. Previously, on your prior iteration of this site plan, the NRCS mapping was relied upon, which says there are sea soils. Is that correct?
Yes.
Okay. And that would require some recharge, correct?
Correct.
Okay. What site conditions have changed?
We performed supplemental soil testing to support the stormwater management, and that supplemental soil testing revealed a groundwater table within 24 inches of the surface and a hydrologic soil group declassification.
Okay. In terms of that 24 inches or less, as you just said it there, under the rule, is it 24 inches or less, or is it less than 24 inches?
It states, I read this earlier, it says a depth of 24 inches or less.
Where are you getting that from?
Chapter 12, Section 1C.
Of the BMP?
That's correct. So on page 9 of the April 2022 review or section, under soil depth profile, pits and borings. About the middle of the paragraph.
Can you read the sentence you're referring to me?
Soil test pits and soil borings performed for the mapping determination of HSG must be at least 40 inches below existing grade, except when the seasonal high water table, and it says SHWT, seasonal high water table is at a depth of 24 inches or less. Should I continue?
Yeah, please do.
The exploration may be terminated before excavating to a depth of 40 inches below existing grade, and the soil is classified as hydrologic soil group D.
Okay, Okay, is the first part of that sentence, do you read that as referring to a reclassification or just how big the soil pits have to be?
No, I refer to it as a reclassification. The sentence I just read to you ends with how the soil should be classified if you encounter that type of condition.
Well, I read it as the exploration may be terminated before excavation to the depth of 40 inches below, and the soils are classified as HSGD. Is that what that says?
This section, subsection 1C that I just read from on page 7 of this is 7 of chapter 12. The title of this section 1C is hydrologic soil group testing procedures.
Understood, but did I read what I read correctly?
I don't dispute what you just read. I don't know if it was right or wrong. I don't recall.
All right. Are you familiar with the National Engineering Handbook?
Yes.
And Part 630, Chapter 7, hydrologic soil groups?
Yes.
All right. What's the relationship between the BMP and the National Engineering Handbook, particularly that section of it?
They refer to that handbook.
Why?
I didn't create the reg. I'm not sure why they did, but it's referencing other characteristics and how do you determine them for soils. It's like a reference.
Okay, so how is the handbook meant to be used?
That has different characteristics of soils and how you interpret them.
Okay, are you familiar with Table 7.1, the criteria for assignment of hydraulic soil group?
Yes.
All right. Are you happen to be looking at that right now?
Yes.
Okay. So I just want to look at that where it's talking about the depth to high water table on the, right there. It says less than 24 inches in that, I guess, top left column. Do you see that? It says depth to high water table, and then 2 boxes down.
It's 20 inches. Okay. Yes.
Okay, and then the next column down is for depth to high water table is greater than or equal to 24 inches. Is that correct?
Yes.
Okay, how does that affect your analysis about whether it needs to be less than or equal to?
It doesn't change it because the regulation that DEP wrote it includes the language I just gave you.
The regulation includes it?
The guidance document, the chapter from the chapter 12.
Doesn't the regulation refer to both the BMP and the National Engineering Handbook?
Yes.
Okay. All right, so let's move on past that point. Would you agree with me that the BMP requires infiltration testing in order to change the NRCS mapping designation?
No, because of the paragraph we just read moments ago.
Okay, so have you done any infiltration testing?
Yes.
What type of infiltration testing did you do?
Basin flood tests and pit bale tests.
Okay, and the pit bale test is no longer an approved testing method, correct?
I wouldn't agree with that because the Chapter 12 allows for alternate tests in certain circumstances, so.
And do you claim that you meet those circumstances?
No, I'm not claiming that. I'm just answering your question regarding whether the pit bale test is permitted or not.
Are the results from either your pit bale test or your basin flood test presented in your report?
No.
So we're not relying on those for purposes of infiltration testing then?
We felt it not necessary to provide infiltration tests because we complied with Chapter 12 with regards to the depth of groundwater table. And we've agreed to provide Mr. Hay with any additional data he requires to be satisfied.
But you did conduct the infiltration test, correct?
That's correct.
Okay. And did those infiltration tests suggest that we have D-soils?
Yes,
But you don't want to show those to us?
because we've already demonstrated it with the depth of groundwater table, sir.
Okay.
We have no trouble providing the township and the board with any tests we've done.
All right, let's talk about your depth to groundwater. I'm looking at your report, Section 8, groundwater recharge, about halfway down the paragraph, if anybody's following along, but I'm going to re-quote. It says, almost every soil exploration that was performed indicated the presence of mottling, that's mottling, at a depth of 24 inches or less. Did I read that correctly?
Yes.
Okay. Can you help me and maybe other people in this room, I don't know, maybe they're smarter than I am, understand what mottling is?
It's a discoloration of the soil that's indicative of a seasonal high groundwater table. The groundwater table fluctuates throughout the year. This mottling occurs because the groundwater table deprives the soil of oxygen, changes the color of the soil.
Okay, so you did soil explorations on 2 different occasions, I believe, in January of 2022 and again in March of this year, this month. Is that correct?
Correct.
Okay. And in January 2022, and feel free to go through this, I count 22 total soil explorations. Does that sound about right to you?
Correct.
Okay. And I count 4 of those soil explorations showing mottling at under 24 inches. And even if we're to include the equal to, there's 3. Is that correct?
I don't dispute it.
Okay. How is that almost every?
Well, because you're not including the soil testing that was just recently done.
Well, I'm asking you about the January one right now. You said almost every soil exploration. Those are soil explorations.
Because the soil testing, to look at it in a vacuum of, it'd be like if you did 1 soil log, or 3 soil logs, and I can only talk about the data from 2 of them. It just seems not appropriate that the supplemental soil testing we did this March in season with the groundwater table present as well indicated modeling in 23 of the 25 test pits within 24 inches, and also indicated seepage and actual groundwater. Like I said earlier, the modeling is an indication of discoloration of soil that would show the presence of groundwater, but the actual in-season soil tests that we performed this March also demonstrated physical evidence of seasonal high groundwater table within 24 inches with seepage and infiltration at those depths. So there was physical evidence that supported the modeling. And that was widespread soil testing throughout the site where we weren't looking at just throughout the site in January of 2022.
Okay, so it's you now who's now telling me not to count the January 2022 logs in this almost every calculation. Is that correct?
No, I'm not saying not to count it. I'm saying that of the 47 we did, 30 of them had modeling. Many of those tests that we did in January of 22 are nearby tests that we did in March of 2023. And with the groundwater present in March of 2023, I felt we can't ignore the physical evidence of groundwater.
All right, so
the water was there.
And I want to talk about the March one specifically, but just to confirm, your testimony is that 30 out of 47 is almost every. Is that correct?
Correct.
Okay. Let's talk about the March soil explorations that were done. It looks like between March 6th and March 8th of this month, correct?
I'm sorry, somebody coughed and I was distracted.
The March soil explorations that we're talking about are dated between March 6th and March 8th of this month, correct?
Correct.
Okay, and this report is dated what?
March 10th.
March 10th.
Right.
It says March 8th on the cover.
March
Okay.
8th. We submitted on the 10th.
Okay. So you did 25 additional soil explorations in between March 6th and March 8th of this month?
Correct.
Okay. And what, by my count, 6 of them are totally under 24 inches for the mottling. Is that count correct? For a second, I'm not counting the ones that range between 12 and 43 inches.
Not all the soil logs had modeling. And I would have to look at the specific soil logs you're referencing, whether there was also perched water or groundwater there as well.
But I'm asking
Not
about,
all of them did.
I'm asking about your reports of the modeling. Only 6 of them had modeling at under 24 inches. 1 of them had it at equal to 24 inches. So is 7 out of 25 almost every?
Well, the criteria is 24 inches or less.
Well, that's why I'm giving you 7. It would be 6 if it was 23.9 or less.
Okay, while Mr. Ford is looking, I just want to remind everyone, since we did start late, we are going to go till 10 o'clock tonight. So, but we are past, because usually we quit at 9:30 if we started on time. You look puzzled.
I just didn't hear you.
Oh, sorry. No, we're going to go till 10, because I know we typically, stop at 9:30, but because we started late, we will go to 10. But obviously, since we're past 9:30, there's not going to be any new testimony, so. You can keep going, Mr. Ford. You're not getting off the, you're going till at least 10.
No, okay, all right.
Thank you.
So of the March 6th through March 8th, soil logs with modeling and/or seepage or groundwater within 24 inches were all but 3 of them.
Well, I'm asking about modeling specifically because that's what we're relying on to change the HSGC.
Or the seasonal high groundwater table taken in season.
What you're determining through the modeling.
No,
Then how are you determining that?
by actually seeing it in the ground, in your in-season. You take a direct measurement to it. For example, soil log 16109 had modeling at 24 inches, but seepage at 17 inches. I'm sorry, 25 inches. Seepage at 17 inches and infiltration at 17 inches.
But your statement referred specifically to the presence of mottling at almost every soil exploration. So that's what I'm trying to figure out.
Okay.
So, again, there's 7 that are below 24. Is it your testimony that 7 out of 25 is almost every?
Let me go back to your question then. Of the 7 that have within, I see soil log 160106 has modeling at 6 inches. 160107 has 20 inches.
160107 has 20 to 30 inches, so I'm not counting that for right now.
You take the highest modeling, sir.
I'm asking you about this.
I don't know what professionally why you would not count that.
And I'd just put the objection for the record that it's a net opinion. Mr. Ash is not a professional engineer.
I'm giving 0 opinion. I'm asking a question about what's written on the paper.
Well, no, he's not counting something. He's saying it's not within 24 inches when one of the numbers is at 20. I'm saying
So,
that's
okay.
within 24 inches.
So even if you want
So I think your characterization that there's only 7 seems inaccurate. And I'm trying to answer your question by reading off all the ones that are within 24 inches.
Please proceed.
Okay. So 9 is at 25 inches. 10 is at 17. 11 is at
For the record, 25 is more than 24.
Correct. 13 is at 19 inches. 14 is at 19 inches. 16 is at 20. 18 is at 22. 19 is at 20. 20 is at 21. 21 is at 14. 23 is at 20. 24 is at 17. I think I've exceeded 7.
So going back to the...
No, I'm not done.
Okay, go ahead.
16,100 is 12 inches. 16,101 is 12 inches. 16,102 is 15 inches. 16,103 is at 24 inches. 16,104 is at 23 inches. And 16,105 is at 12 inches. Okay?
Okay, so by your count, you have 30 out of 47, just to reiterate. And that's your testimony that that's almost every. Is that what your position is?
Asked and answered objection.
Well, he just went through them all, so I'm just trying to clarify what the testimony is.
Move on, Mr. Ash.
And do you have, do you have a point to all this questioning? I'm sure that you do, and he's answering, but is there...
I'm trying to clarify what is almost every for the modeling he's relying on to change the HSG C to D.
Do you have a definition of what almost every is? That
I'm not making the statement.
Okay.
I want to know what his definition is.
Okay.
Yeah, I think in fairness is he's reading lines in a report, and perhaps our staff summarized it too briefly, because as I've already testified, our characterization of the groundwater within 24 inches didn't rely just on modeling, and substantially relied on additional data in season with depth to groundwater table, which is something you can physically measure.
Just to clarify, sir, you signed this report and are testifying.
That's correct.
Correct?
That's correct.
Okay. And the March 6th to 8th soil explorations that were done allowed you to change the entire stormwater site design in the course of a day. Is that correct?
And not a day. There was 3 days of testing.
But then you submitted this report dated the same day as the testing.
That's correct.
Okay. Let's move on to water quality. So for water quality purposes, your plan proposes, am I correct, several what are called manufactured treatment devices. Is that correct?
Correct.
Okay. How many of these manufactured treatment devices are included on your plan?
I don't have that count. I would have to open up the plans and count each one.
Okay. Is it more than 10?
I believe so, yes.
More than 20?
No, I don't believe there's that many.
Okay.
But I don't have the numbers.
No, that's fine. I'm just trying to get a rough grasp of what we're talking about here.
It's dictated by the drainage area.
Understood. And you would agree with me that these manufactured treatment devices need to be properly sized to manage the incoming runoff. Is that correct?
Correct.
Okay. Did you or your firm do the engineering calculations to determine the unit sizes for the, I'm going to call them MTDs on this site?
That normally is done by the supplier that tells us whether they're manufactured treatment devices, so the supplier really has to tell you whether their device is adequate for that flow.
Okay, and what did you do to check that the manufacturer's calculations were consistent with BMP requirements?
I'm sorry, I couldn't really hear you because you were too close.
Too close. That's a new one. What did you do to check that the manufacturer's calculations were consistent with BMP requirements?
The manufacturer provides us with a certification that their device has met the NJDP protocol.
Okay. So, are you aware of whether this manufacturer used a calculated time of concentration, or if they used a minimum or default value?
I don't have that answer right now.
Okay. I'm going to look at, and I invite you to look along with me, Appendix G to your report. And are you aware that it says here that the time of concentration value of default 10 minutes was used by the manufacturer?
Yes.
Okay, and are you aware that Chapter 5, on page 24 of the BMP states, in bold print, mind you, that, quote, "there is no longer a minimum of default value that may be used for the time of calculation"?
Not sure that that applies to MDD sizing. That may apply to stormwater collection systems. But we'll address that.
Please do. All right, let's move on to peak runoff. We have time? Yeah, we got some time. So, peak runoff is determined, am I correct, by calculating existing and proposed conditions of runoff. Is that correct?
Yes.
Okay. For your existing and proposed conditions, did you use a C or a D HSG designation, excuse me?
I believe we used the C to be conservative. If we used the D, that would yield less conservative results.
Which one did you use?
C for the quantity.
For the peak runoff calculations?
Correct.
Okay. So you previously indicated that the existing state open water and the pipes going under Weston Road create a restriction to the water leaving the property. You recall that testimony?
Don't recall any statement about restrictions.
Okay, I'm going to read to you from your testimony on November,
Sure.
What was it, 10th, 2022? Quote, and what I think I'd also like to point out in this case is that we're connecting to an existing stormwater pipe, which does run under Weston Road, and as was discussed at the Environmental Commission, connects to the basin in the community across the street. That pipe has a restriction, that has a restriction. That is another control point that we're not looking to change. If we had such great flow from our site and such great increase in peak flow, your board engineer would be asking us to fix that pipe, making it bigger, making it larger, doubling the size. Does that refresh your memory?
Yes.
Okay.
Yes.
So why aren't these restrictions represented in your existing conditions calculations?
In the existing condition calculations for what
For
aspect?
peak runoff?
The peak runoff is the discharge from our site.
Right, and those two features are restrictions to the runoff from your site.
That would be a restriction, but that doesn't change the flow from our site. When you're calculating existing conditions, you're calculating the flow from your site.
So the restrictions would be applicable to calculate those flows, correct?
No.
How would they not be?
Those flows are representative of what the flow is from the site, not some restriction downstream. The restriction downstream, as we discussed earlier, was considered as part of our analysis of the overall stormwater management piping network, the piping.
So is your testimony now today that those features do not slow the runoff from this site?
No, my testimony is that they don't impact the allowable discharge from this site in existing conditions and how you calculate that.
All right, are you aware that under the stormwater management rules at 7:8-5.7A3, the design engineer is required to, quote, account for all features and structures that may reduce pre-construction stormwater rates and volumes?
What was that quote? What was that site again, Counselor?
NJAC 7:8-5.7A3.
Thank you.
Yeah. Again, my understanding of that section of the code you're referring to is with regards to calculating the runoff from this site. For example, if there was an existing basin or something else that would impact the discharge from the site. That would impact the total flow coming from the site.
All right, so with regard to your peak flow rate analysis, and I'm looking at your tables 5.1 through 5.3, where exactly was your point of analysis located for these calculations?
Just downstream of our site.
Downstream, can you kind of point out to me where, please?
In this area where we're connecting to this pipe, and then we have the other bypass from our site. So in that area.
So your point of analysis is right where your mouse is right now?
I'm saying it's downstream of our site, just downstream, right here.
Okay. Is it at the point of discharge?
Yes.
You hesitated there.
No, well, because there's two discharges. There's one discharge from the basin, and there's one discharge from the bypass. And in engineering practice, essentially they're the same place from this site, so that's, you use one point of analysis.
So you
both analyze separately, but use one point of analysis.
So your point of analysis is one of those points of discharge, is that correct?
Well, it's a summary of those two, so when you look at a specific point, it's not.
Okay. Did you use a what's called a weighted approach to calculate the required peak flow?
A weighted approach in what regard?
A weighted approach with regards to disturbed acreage and or the flow rate.
So, not speaking in engineering language that I'm familiar with.
Please rephrase.
Okay.
Yeah. I mean, we as part of the analysis, we used the existing land cover to determine the CN numbers, the coefficients for the runoff. Different types of land cover have different runoff characteristics, and as part of the analysis, we would use, if there's different land covers, a weighted average of those different land covers, and then the impervious coverage is calculated separate in a separate hydrograph. So I don't know if that's what you're referring to with whether we use weighted, but that's the only thing that I can think of you might be referencing. It just didn't seem phrased.
Okay, I appreciate that. And I'm not an engineer, so I probably misphrase things from an engineering standpoint. I have a few questions about your off-site stormwater impact analysis, which is your other report. Also, I think dated March 8th, is that correct?
Correct.
Okay. So the point of interest or point of analysis that you use there is not at the end of your site, and is not at the private pipe that you propose to connect to. What is the point of analysis for that report?
We used the same point of analysis that was used in the drainage report done by others for the West Mead project. So the downstream side of the West Mead project.
So that location was chosen solely based on what was previously done?
No, that was chosen to determine what the impact would be at the downstream point of West Mead as a result of this project. And we have two numbers that we provided in the report. One was the change in that peak flow, which was, I think, only 16 CFS less, albeit less, but not significant. And then the change in the discharge from Basin C as a result of the reduction in drainage area to Basin C. And that was, I believe, a 23% reduction in runoff.
Okay, and circling back to the on-site analysis, well, maybe not the on-site analysis, but the delayed release of 17 hours that you're now proposing. Did you analyze the impact of this delay on the full drainage area?
That was part of our analysis, so yes, yeah.
What, as part of what analysis?
Well, when we did the off-site analysis, that supplemental report that's not required by code, but we did it is we used the same routing through our basin, so the delay in the peak discharge would have been included as part of that analysis.
But did you analyze that as compared to the peak flow with regards to the full drainage area?
Don't understand your question.
All right, I'll move on. With regards to the operation and maintenance of the on-site stormwater facilities, who was responsible?
The owners of the facility.
And how is that to be enforced?
There's there's an operation and maintenance manual that's prepared. We prepared it for this project. And typically, the township requires that that be recorded at the county clerk's office as a restriction to notify any property owners, any subsequent property owners.
Will there be any sort of escrow or fund set up for that operation and maintenance?
That really would be private landowners. In this case, there's not a homeowners association, so I don't think that would be required.
Okay, and with regards to the pipe that flows under the Weston Road and onto the Hearthstone property, who's responsible for the maintenance of that pipe?
The pipe within the public right-of-way is the township's responsibility, and with regards to the responsibility of the pipe maintenance on the Hearthstone project, I don't know the answer.
Okay, who's responsible for that piping system if there were an overcapacity flow and something were to go wrong?
Just answered that. Yeah, I think it's the same as the first answer I just gave you.
So the public, and then you don't know?
I don't know. Correct.
Okay. What do we got? 9:57. All right, I'll keep going until we got to stop. I don't have a whole lot more, but with regards to the Hillsborough Stream Corridor Ordinance, I just want to confirm that the newly revised site plan completely avoids the stream corridor?
Yes.
Okay. And this would have required an averaging plan if it were encroached upon. That is no longer being proposed, is that correct?
Correct.
Okay, how did this change impact the site plan design?
It reduced the amount of impervious. It reduced the impacts to the wooded area. And, the averaging plan is, for stream corridor is something that is permitted by the ordinance, but subject to board approval. But we chose to not continue to make that request.
Did it have any impact on circulation, truck circulation?
The two end truck docks would have to make a right, and then, actually, the end truck, there actually, excuse me, let me correct that. Let me highlight it now. The end space in the loading area is a ramp up into the building, so that's not for truck docks. The two truck docks just to the north of the access door would not be able to make a left out and then continue out. They would actually have to go to the end, make a U-turn, and then come out. So it had an adverse impact on internal circulation.
Okay. I see it's 9:59. I don't have a whole lot more, but more than 1 minute. Do we maybe want to break until next time, or what do we want to do?
Probably best to break so we don't rush through it.
Sure.
Okay. So with that, it's 10 o'clock. We're going to be ending our meeting this evening. Just a reminder that this hearing is already scheduled to continue May 4th, 7 p.m. here. And there won't be any additional notice.
We need a resolution.
Do we need a resolution to continue?
We need a motion to continue.
Okay.
Folks,
If you're exiting, please do it quietly. We still have a couple of housekeeping items.
It's a motion, Mr. Chairman, to continue this hearing till May 4th, 2023 at 7 p.m. or as soon thereafter as the matter may be heard without further notice.
Okay.
So moved, Mr. Chairman.
Okay, Mr. Peason moved it. Do I have a second?
Second.
And Mr. Scobo seconded it.
All in favor?
All in favor? Aye. There are no nays. So with that, again, a reminder, our next meeting is April 13th. I am assuming that we have something on the schedule, Mr. Coyce?
Oh, yes, several possible
We have-
items.
So we're going to wind up with something on the schedule.
Oh, there is already 2 items on, and there may be 2 more.
Okay. All right. With them, I have a motion of adjournment.
So moved.
Second.
All in favor? Aye. We're adjourned. Have a good holidays, and we'll see everybody on the 13th.